Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Snehalatha Singhi vs. Deputy Commissioner of Income Tax, Bangalore Tribunal, pronounced on the 17th of April 2026. The assessee, an individual and director of Messrs. BMM Ispat Limited, filed a belated return for assessment year 2012-13, treated as invalid. Based on AIMS information regarding penny stock issues, the AO issued a notice under Section 148 on the 28th of March 2019, after PCIT approval on the 26th of March 2019. The assessee responded, but technical issues with the e-proceedings portal delayed compliance. The AO issued multiple notices under Section 142(1) and a show cause notice on the 16th of December 2019, proposing best judgment assessment under Section 144. The assessee filed objections on the 26th of December 2019 at 1:51 p.m. and again at 7:36 p.m. challenging the validity of the reopening and requesting the proceedings be dropped. The AO disposed of the earlier objection but failed to pass a speaking order on the later objection. Consequently, the AO completed the reassessment under Section 143(3), read with Section 147, making additions of Rs 16 crore, 51 lakh, 45,586 under Section 68 and Rs 49 lakh, 54,368 under Section 69C, relying on investigation reports and a SEBI order. The NFAC upheld the S order, leading to the appeal before the ITAT. The ITAT focused on the procedural requirement established in GKN Drive Shafts, India, Limited vs. ITO, which mandates that when an assessee files objections to the reasons recorded for reopening, the AO must dispose of those objections by a speaking order before passing the reassessment order. In this case, the assessee filed two sets of objections on the 26th of December 2019. The AO considered only the first objection and issued a speaking order on the 27th of December 2019. However, the second objection, which specifically requested dropping proceedings under Section 148, was not addressed. The tribunal relied on the Karnataka High Court's judgment in Hewlett-Packard Financial Services, India, vs. DCIT, which held that non-disposal of objections by a speaking order makes the assessment order unsustainable. The High Court emphasized that the S duty is a substantive safeguard against arbitrary reopening. The ITAT noted that the AO had furnished reasons on the 24th of December 2019, and objections were filed promptly. Despite this, the AO passed the reassessment order without addressing the second objection, thereby vitiating the entire proceedings. The procedural flaw was fatal. Consequently, the ITAT set aside the notice under Section 148 and the order under Section 143(3), read with Section 147, without adjudicating the merits of the additions. This aligns with the principle that procedural irregularities affecting jurisdiction must be rectified before substantive issues are examined. The S decision reinforces the critical importance of procedural compliance in reassessment proceedings. By holding that the S failure to dispose of objections by a speaking order renders the reassessment invalid, the tribunal upheld the principles of natural justice and the rule of law. The ruling serves as a reminder that the GKN Drive Shafts procedure is mandatory, and any deviation, even in cases involving alleged tax evasion, cannot be condoned. For assessees, this judgment provides a strong legal ground to challenge reassessment orders where procedural safeguards are breached. The case also highlights the need for S to meticulously document and address all objections raised by assessees, especially in complex matters involving penny stocks and investigation reports. This decision is likely to be cited in similar disputes, reinforcing fair tax proceedings. Question: what is the significance of the GKN drive shafts procedure in reassessment cases? Answer: the GKN drive shafts procedure requires the assessing officer to provide the reasons for reopening an assessment under Section 147 to the assessee upon request and to dispose of any objections raised by the assessee through a speaking order before passing the reassessment order. This ensures transparency and natural justice. Question: why did the ITAT set aside the reassessment order in this case? Answer: the ITAT set aside the reassessment order because the AO failed to dispose of the assessee's objections to the reasons for reopening by a speaking order, as required by the GKN drive shafts procedure. The tribunal relied on the Karnataka High Court's judgment in Hewlett-Packard Financial Services, India, versus DCIT, which held that such non-disposal makes the assessment order unsustainable. Question: did the ITAT examine the merits of the additions made by the AO? Answer: no, the ITAT did not adjudicate the merits of the additions under Sections 68 and 69C. The appeal was allowed solely on the legal ground of procedural violation, and the other issues were not considered. Question: what is the impact of this decision on future reassessment proceedings? Answer: this decision reinforces that procedural compliance is paramount in reassessment proceedings. Assessing officers must ensure that all objections raised by assessees are addressed through speaking orders, otherwise, the reassessment order may be invalidated, even if substantive allegations of tax evasion exist. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org, or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.